International Standby Practices ISP 98 ISP 98 এর রুল আছে 10টা। 10টা রুল আছে। রুল 1 General Provisions, Scope, Application, Definition and Interpretation of these rules. Scope and application. These rules are intended to be applied to standby letters of credit, including performance, financial and direct pay standby letters of credit. A standby letter of credit or other similar undertaking, however named or described, whether for domestic or international use, may be made subject to these rules by express reference to them. An undertaking subject to these rules may expressly modify or exclude their application. D. An undertaking subject to these rules is thereafter referred to as a standby. 1.02 Relationship to law and other rules. These rules supplement the applicable law to the extent not prohibited by that law. B. These rules supersede conflicting provisions in any other rules of practice to which a standby letter of credit is also made subject. Interpretative principles. These rules shall be interpreted as mercantile uses with regard to integrity of standbys as reliable and efficient undertakings to pay, practice and terminology of banks and business in day-to-day transactions, inconsistency within the worldwide system of banking operations and commerce, and worldwide uniformity in their interpretation and application. 1.04 Effect of the rules. Unless the context otherwise requires, or unless expressly modified or excluded, these rules apply as terms and conditions incorporated in a standby. Confirmation, advice, nomination, amendment, transfer, request for issuance or other agreement of the issuer, the beneficiary to the extent it issues the standby, any advisor, any confirmer, any person nominated in the standby who acts or agrees to act, and the applicant who authorizes issuance of a standby or otherwise agrees to the application of these rules. Exclusion of matters related to due issuance and fraudulent or abusive drawing. These rules do not define or otherwise provide for power or authority to issue a standby, formal requirements for execution of a standby, e.g. a signed writing, or defenses to honor based on fraud, abuse or similar matters. These matters are left to the applicable law. General principles. Nature of standbys. A standby is an irrevocable, independent, documentary and binding undertaking when issued and need not so state. Because a standby is irrevocable, an issuer's obligation under a standby cannot be amended or cancelled by the issuer except as provided in the standby or as consented to by the person against whom the amendment or cancellation is asserted. C. Because a standby is independent, the enforceability of an issuer's obligations under a standby does not depend on the issuer's right or ability, reimbursement from the applicant, the beneficiary's right to obtain payment from the applicant, a reference in the standby to any reimbursement agreement or underlying transaction, or the issuer's knowledge of performance or breach of any reimbursement agreement or underlying transaction. Because a standby is documentary, an issuer's obligation depends on the presentation of documents and an examination of required documents on their face. Because a standby or amendment is binding when issued, it is enforceable against an issuer whether or not the applicant authorized its issuance, the issuer received a fee, or the beneficiary received or relied on the standby or the amendment. On page 07, interdependence of the issuer-beneficiary relationship. An issuer's obligation toward the beneficiary are not affected by the issuer's right and obligations toward the applicant under any applicable agreement, practice or law. Limits to responsibilities. An issuer is not responsible for performance or breach of any underlying transaction. Accuracy, genuineness or effect of any document presented under the standby. Action or omission of others, even if other person is chosen by the issuer or nominated person, or observance of law or practice other than that chosen in the standby or applicable at the place of terminology. Defined terms. In addition to the meanings given in the standard banking practice and applicable law, the following terms have or include the meanings indicated below. A. Definitions. Applicant is a person who applies for issuance of a standby or for whose account it is issued, and includes a person applying in its own name but for the account of another person. 2. An issuer acting for its own account. Beneficiary is a named person who is entitled to draw under a standby. Business day means a day on which a place of business at which the relevant act is to be performed is regularly open. And banking day means a day on which the relevant bank is regularly open at the place at which the relevant act is performed. Confirmer is a person who, upon an issuer's nomination to do so, adds to the issuer's undertaking its own undertaking to honor a standby. Demand means, depending on the context, either a request to honor a standby or a document that makes such request. Document means a draft, demand, document of title, investment security, invoice, certificate of default, or any other presentation of fact, law, right or opinion that upon presentation, whether in a paper or electronic medium, is capable of being examined for compliance with the terms and conditions of the standby. Drawing means, depending on the context, either a demand presented or a demand honored. Expiration date means the latest day for a complying presentation provided in a standby. Person includes a natural person, partnership, corporation, limited liability company, government agency, bank, trustee or any other legal or commercial association or entity. Presentation means, depending on the context, either the act of delivering documents for examination under a standby or a documents so delivered. Presenter is a person who makes a presentation as or on behalf of a beneficiary or nominated person. Signature includes any symbol executed or adopted by a person with a present intent to authenticate a document. B. Cross-reference. C. Electronic presentation. The following terms in a standby providing for or permitting electronic presentation shall have the following meanings unless the context otherwise requires. Electronic presentations. The following terms in a standby providing for or permitting electronic presentation shall have the following meanings unless the context otherwise requires. Electronic record means a record, information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in a perceivable communicated by electronic means to a system for receiving, storing, retransmitting or otherwise processing information. Data, text, image, sounds, codes, computer programs, software, database and the like. And C. Capable of being authenticated and then examined for compliance with the terms and conditions of the standby. Authenticate means to verify an electronic record by generally accepted procedure or methodology in commercial practice. The identity of a sender or a source and the integrity of or errors in the transmission of information content. The criteria for assessing the integrity of information in an electronic record is whether the information has remained complete and unaltered, apart from the addition of any endorsement or any change which arises in normal course of communication, storage and display. Electronic signature means letters, characters, numbers or other symbols in electronic form attached to or logically associated with an electronic record that are executed or adopted by a party with present intent to authenticate an electronic record. Receipt occurs when an electronic record enters in a form capable of being processed by the information system designated in the standby, or an issuer retrieves an electronic record sent to an information system other than the designated by the issuer. 1.10 Redundant or otherwise undesirable terms. A standby should not or need not state that it is unconditional or abstract. If it does, it signifies merely that payment under it is conditional solely on presentation of specified documents. 2. Absolute. If it does, it signifies merely that it is irrecoverable. Primary. If it does, it signifies merely that it is the independent obligation of the issuer. 4. Payable from the issuer's own hand. If it does, it signifies merely that payment under it does not depend on the availability of applicant funds and is made to satisfy the issuer's own independent obligation. Clean or payable on demand. If it does, it signifies merely that it is payable upon presentation of a written demand or other documents specified in the standby. B. A standby should not use the term and, or. If it does, it means either or both. C. The following terms have no single accepted meaning and shall be disregarded. Callable, divisible, fractionable, indivisible, transmissible. 2. And shall be disregarded unless their context gives them meaning. Assignable, evergreen, reinstate and revolving. Interpretation of these rules. These rules are to be interpreted in the context of applicable standard practice. In these rules, standby letter of credit refers to the type of independent undertaking for which these rules were intended, whereas standby refers to an undertaking subject to these rules. unless the context otherwise requires. A. Issuer includes a confirmer as if the confirmer were a separate issuer and its confirmation were a separate standby issued for the account of the issuer. 2. Beneficiary includes a person to whom the named beneficiary has effectively transferred drawing rights. Transferee beneficiary. Including means including but not limited to. A or B means A or B or both. Either A or B means A or B but not both, and A and B means both A and B. Odds in the singular number include the plural and the plural include the singular. Odds of the neuter gender include any gender. The use of phrase unless a standby otherwise states or the like in a rule emphasizes that the text of the standby controls over the rule. Text of the standby controls over the rule. Absence of such a phrase in other rules does not imply that other rules have priority over the text of the standby. 3. Addition of the term expressly or clearly to the phrase unless a standby otherwise states or the like emphasizes that the rule should be excluded or modified only by wording in the standby that is specific and unambiguous. 4. While the effect of all the rules may be varied by the text of the standby, variation of the effect of some of these rules may disqualify the standby as an independent undertaking under the applicable law. The phrase stated in the standby or the like refers to the actual text of a standby, whether as issued or effectively amended, whereas the phrase provided in the standby or the like refers to both the text of the standby and these rules are incorporated. Rule 2. Obligations. Undertaking to honor by issuer and any confirmer to beneficiary. An issuer undertakes to the beneficiary to honor a presentation that appears on its face to comply with the terms and conditions of the standby in accordance with these rules supplemented by standard standby practice. An issuer honors the complying presentation made to it by paying the amount demanded of it at sight, unless the standby provides for honor. By acceptance of a draft drawn by the beneficiary on the issuer, which case the issuer honors by timely accepting the draft and thereafter paying the holder of the draft on presentation of the accepted draft on or after its maturity. By deferred payment of a demand made by the beneficiary on the issuer, in which case the issuer honors by timely incurring a deferred payment obligation and thereafter paying at maturity. 3. By negotiation, in which case the issuer honors by paying the amount demanded at sight without recourse. C. An issuer acts in a timely manner if it pays at sight, accepts a draft or undertakes a deferred payment obligation, or if it gives notice of dishonor within the time permitted for examining the presentation and giving notice of dishonor. D1. A confirmer undertakes to honor a complying presentation made to it by paying the amount demanded of it at sight, or if the standby so states, by another method of honor consistent with the issuer's undertaking. 2. If the confirmation permits presentation to the issuer, then the confirmer undertakes also to honor upon the issuer's wrongful dishonor by performing as if the presentation had been made to the confirmer. 3. If the standby permits presentation to the confirmer, then the issuer undertakes also to honor under the confirmer's wrongful dishonor by performing as if the presentation had been made to the issuer. An issuer honors by paying in immediately available funds in the currency designated in the standby, unless the standby states it is payable by payment of a monetary unit of account, in which case the undertaking is to pay in that unit of account, or delivery of other terms of value, in which case the undertaking is deliver those terms. Obligation of different branches, agencies or other offices. For the purpose of these rules, an issuer, branch, agency or other office acting or undertaking to act under a standby in a capacity other than an issuer is obligated in that capacity only and shall be treated as a different person. Conditions to issuance. A standby is issued when it leaves an issuer's control, unless it clearly specifies that it is not issued or enforceable. Statements that a standby is not available, operative, effective or the like do not affect its irrevocable and binding nature at the time it leaves the issuer's control. Nomination. A standby may nominate a person to advise, receive a presentation, effect a transfer, confirm, pay, negotiate, incur a deferred payment obligation or accept a draft. Nomination does not obligate the nominated person to act except to the extent that the nominated person undertakes to act. A nominated person is not authorized to bind the person making the nomination. Advice of standby or amendment. Unless an advice states otherwise, it signifies that the advisor has checked the apparent authenticity of the advised message in accordance with the standard letter of credit practice, and the advice accurately reflects what has been received. A person who is requested to advise a standby and decides not to do so should notify the requested party. When an amendment is authorized and binding. If a standby expressly states that it is subject to automatic amendment by an increase or decrease in the amendment available, an extension of the expiration date or the like, the amendment is effective automatically without any further notification or consent beyond that expressly provided for in the standby. Such an amendment may also be referred to as becoming effective without amendment. If there is no provision for automatic amendment, an amendment binds the issuer when it leaves the issuer's control, the confirmer when it leaves confirmer's control, unless the confirmer indicates that it does not confirm the amendment. If there is no provision for automatic amendment, the beneficiary must consent to the amendment for it to be binding. The beneficiary's consent must be made by an express communication to the person advising the amendment, unless the beneficiary presents documents which comply with the standby as amended and which would not comply with the standby prior to such amendment, and an amendment does not require the applicant's consent to be binding on the issuer, the confirmer or the beneficiary. Consent to only part of an amendment is rejection of the entire amendment. Routing of amendments. An issuer using another person to advise a standby must advise all amendments to that person. An amendment or cancellation of a standby does not affect the issuer's obligation to a nominated person that has acted within the scope of its nomination before receipt of notice of the amendment or cancellation. Non-extension of an automatically extendable renewable standby does not affect an issuer's obligation to a nominated person who has acted with the scope of its nomination before receipt of a notice of non-extension. Rule 3. Presentation. Complying presentation under a standby. A standby should indicate the time, place and location. Within that place, person to whom and medium in which presentation should be made. If so, presentation must be so made in order to comply. To the extent that a standby does not so indicate, presentation must be made in accordance with these rules in order to be complying. What constitutes a presentation? The receipt of a document required by and presented under a standby constitutes a presentation requiring examination for compliance with the terms and conditions of the standby, even if not all the required documents have been presented. Identification of standby. A presentation must identify the standby under which the presentation is made. A presentation may identify the standby by stating the complete reference number of the standby and the name and location of the issuer, or by attaching the original or a copy of the standby. C. If the issuer cannot determine from the face of the document received that it should be processed under a standby, or cannot identify the standby to which it relates, presentation is deemed to have been made on the date of identification. (3.04) Where and to whom complying presentation made. To comply, a presentation must be made at the place and any location at that place indicated in the standby or provided in these rules. If no place of presentation to the issuer is indicated in the standby, presentation to the issuer must be made at the place of business from which the standby was issued. If a standby is confirmed but no place for presentation is indicated in the confirmation, presentation for the purpose of obligating the confirmer (bracket) and the issuer (bracket close) must be made at the place of business of the confirmer from which the confirmation was issued, or to the issuer. D. If no location at a place of presentation is indicated, such as department floor, room, station, mail shop, post office box or other location, presentation may be made to the general postal address indicated in the standby, any location at the place designated to receive deliveries of mail or documents, or any person at the place of presentation actually or apparently authorized to receive it. When timely presentation made. A presentation is timely if made at any time after issuance and before expiry on the expiration date. A presentation made after the close of business at the place of presentation is deemed to have been made on the next business day. Complying medium of presentation. A. To comply, a document must be presented in the medium indicated in the standby. B. Where no medium is indicated, to comply, a document must be presented as a paper document unless only a demand is required, in which case a demand that is presented via SWIFT, tested telex or other similar authenticated means by a beneficiary, that is a SWIFT participant or a non-compliant or a bank, complies. Otherwise, a demand that is not presented as a paper document does not comply unless the issuer permits in its sole discretion the use of that medium. A document is not presented as a paper document if it is communicated by electronic means, even if the issuer or nominated person receiving it generates a paper document from it. Where presentation in an electronic medium is indicated, to comply, a document must be presented as an electronic record capable of being authenticated by the issuer or nominated person to whom it is presented. 3.07 Separateness of each presentation. A. Making a non-complying presentation, withdrawing a presentation, or failing to make any one of a number of a scheduled or permitted presentation does not waive or otherwise prejudice the right to make another timely presentation or a timely presentation whether or not the standby prohibits partial or multiple drawings or presentation. Otherwise prejudice মানে ক্ষুণ্ণ করা. B. Wrongful dishonor of a complying presentation does not constitute dishonor. Wrongful dishonor of a complying presentation does not constitute dishonor of any other presentation under a standby or repudiation of the standby. Repudiation মানে বাতিল করা. আচ্ছা. C. Honor of a non-complying presentation with or without notice of its non-compliance does not waive requirements of a standby for other presentations. 3.08 Partial drawings and multiple presentations. Amount of drawings. A presentation may be made for less than the full amount available. Partial drawing bracket a partial drawing. B. More than one presentation, multiple presentation bracketer মধ্যে may be made. C. The statement partial drawings prohibited or a similar expression means that a presentation must be for the full amount available. The statement multiple drawings prohibited or a similar expression means that only one presentation may be made and honored, but that it may be for less than the full amount available. E. If a demand exceeds the amount available under the standby, the drawing is discrepant. Any document other than the demand stating an amount in excess of the amount demanded is not discrepant for that reason. F. Use of approximately, about, circa মানে হলে about, or a similar word permits a tolerance not to exceed 10% more or 10% less of the amount to which such word refers. 3.09 Extend or pay. A beneficiary's request to extend the expiration date of the standby or alternatively to pay the amount available under it is a presentation demanding payment under the standby to be examined as such in accordance with these rules and implies that the beneficiary consents to the amendment to extend the expiry date to the date requested. Requests the issuer to exercise its discretion to seek the approval of the applicant and to issue that amendment. Upon issuance of that amendment, retracts its demand for payment and consents to the maximum time available under these rules for examination and notice of dishonor. No notice of receipt or presentation. An issuer is not required to notify the applicant of receipt of a presentation under the standby. 3.11 Issuer waiver and applicant consent to waiver of presentation rules. In addition to other discretionary provisions in a standby or these rules, an issuer may, in its sole discretion, without notice to or consent of the applicant and without effect of the applicant's obligation to the issuer, waive A. The following rules and any similar terms stated in the standby, which are primarily for the issuer's benefit or operational convenience. Treatment of documents received at the request of the presenter as having been presented at a later date. 2. Identification of a presentation of the standby under which it is presented. 3. Where and to whom the presentation is made and except the country of presentation stated in the standby. Or 4. Treatment of a presentation made after the close of business as if it were made on the next business day. B. The following rule but not similar terms stated in the standby. A required document dated after the date of its stated presentation. Or the requirement that a document issued by the beneficiary be the language of the standby. The following rule relating to the operational integrity of the standby only in so far as the bank is in fact dealing with the true beneficiary. Acceptance of a demand in an electronic medium. Waiver by the confirmer requires the consent of the issuer with the respect of paragraph B and C of this rule. 3.12 Original standby lost, stolen, mutilated or destroyed. A. If an original standby is lost, stolen, mutilated or destroyed, the issuer need not replace it or waive any requirement that the original be presented under the standby. B. If the issuer agrees to replace an original standby or to waive a requirement for its presentation, it may provide a replacement or copy to the beneficiary without affecting the applicant's obligation to issuer to reimburse. But if it does so, the issuer must mark the replacement or copy as such. The issuer may, in its sole discretion, require indemnities satisfactory to it from the beneficiary and assurance from the nominated person that no payment has been made. Closure on expiry date. 3.13 Expiration date on a non-business day. A. If the last day for presentation stated in the standby bracket, whether stated to be the expiration date or the date by which the documents must be received bracket close, is not a business day of the issuer or nominated person where presentation is to be made, then presentation made thereon the first following business day shall be deemed timely. B. A nominated person to whom such a presentation is made must so notify the issuer. 3.14 Closure on a business day and authorization of another reasonable place for presentation. A. If on the last business day for presentation the place for presentation stated in a standby is for any reason closed and presentation is not timely made because of the closure, then the last day of presentation is automatically extended to the day occurring 30 calendar days after the place of presentation reopens for business unless the standby otherwise provides. B. Upon or in anticipation of closure of the place of presentation, an issuer may authorize another reasonable place for presentation in the standby or in a communication received by the beneficiary. If it does so, then presentation must be made at that reasonable place. 2. If the communication is received fewer than 30 calendar days before the last day for presentation and for that reason presentation is not timely made, the last day for presentation is automatically extended to the day occurring 30 calendar days after the last day for presentation. Rule 4 third number rule examination. 4.01 Examination for compliance. A. Demands for owner of a standby must comply with the terms and conditions of the standby. B. Whether a presentation appears to comply is determined by examining the presentation on its face against the terms and conditions stated in the standby as interpreted and supplemented by these rules. which are to be read in context of standard standby practice. Non-examination of extraneous documents. The documents presented which are not required by the standby need not be examined, and in any event shall be disregarded for purpose of determining compliance of the presentation. They may without responsibility be returned to the presenter or passed on with the other documents presented. Examination for inconsistency. An issuer or nominated person is required to examine the documents for inconsistency with each other only to the extent provided in the standby. Language of documents. The language of all documents stated in the beneficiary to be that of the standby. Issuer of documents. Any required document must be issued by the beneficiary unless the standby indicates that the document is to be issued by a third person, or the document is of a type that standard standby practice requires to be issued by a third person. Date of documents. The issuance date of a required document may be earlier but not later than date of presentation. Required signature on a document. A required document need not be signed unless the standby indicates that the document must be signed or the document is of a type that standard standby practice requires be signed. B. A required signature may be made in any manner that corresponds to the medium in which the signed document is presented. C. Unless a standby specifies the name of a person who must sign a document, any signature or authentication will be regarded as a complying signature. The status of a person who must sign. No indication of the status is necessary.